Good afternoon and welcome to our webinar today on the student loan forgiveness programs, or programs, I should say, launched by the Biden administration. My name is Gregg Nunziata, and I am the Executive Director for the Society for the Rule of Law. Before we start, I just, for those of you who don't know, wanted to tell you a little bit about the Society. We are a membership organization of principally lawyers, but also others who prioritize the defense of the rule of law, the Constitution, and ultimately democracy. And we really welcome our membership, we welcome our friends, and we hope if you enjoy this program and enjoy other programming we are doing, you will consider joining. Our membership has several tiers, and as I mentioned, it's not just for lawyers. We believe the rule of law and the Constitution are things more important than lawyers alone, and that every American has a role in defending these pieces of our heritage that are so important to American flourishing. Speaking of programming, our next event will be 2 weeks from today at the same time, and that will be another webinar, and that's going to be on the presidential pardon power, its scope, its potential abuses over time and in the future, and lots of interesting legal questions now about presidential pardon powers, as well, connected to our arguments about impeachment and presidential immunity and others going on. So it should be a rich conversation. The announcement will be on our website with participants listed. Now I'd like to just tell you just a few things about the logistics here. We're going to talk amongst us and the panelists probably for about 45 minutes. There'll be room for audience Q&A at the end. The best way to submit a question is to put it in the chat function on Zoom, and I will scroll through and try to get to as many questions as I can. We do have limited time. But with that, I'd like to launch into the program and introduce our amazing panel. We have with us today, who will be opening up the conversation for us, is Dan Currell. Dan is the former Deputy Undersecretary of the Department of Education and Senior Advisor to the Secretary during the prior administration. Dan also, just this weekend, had a really terrific long essay in New York Times opinion section about the college admissions process. So it's tangentially related to what we're talking about today, and perhaps Dan will have a chance to discuss it a bit. We have a link to that story also just dropped in the chat. Sheng is litigation counsel to the New Civil Liberties Alliance and former counselor to the the administrator at the U.S. Department of Labor, also in the former administration. Stuart Gerson is the board treasurer for the Society of the Rule of Law, so one of our own, and he's the former acting attorney general of the United States. It is a terrific panel. I'm really grateful to the three of you for carving out time on a Tuesday to join this conversation. And with that, I would like to ask Dan if he could open up the conversation for us.
Great. Gregg, thank you very much for the kind introduction, and thanks everybody for joining us. This is a large issue in many ways. I am going to talk briefly, I think, and mostly to kind of frame the shape and scale of the thing. And then I do have a few comments just to toss in there up front about sort of implications for rule of law and kind of the polity. So I may be mercifully the only person who has brought any slides today, and I don't have many. I really have three. And so if I press this button and I'm successful, I may have just been successful. Excellent. I've been successful, I believe. And as you can see, my slideshow is titled "How to Spend $1 Trillion on School Supplies." Those pencils there are very, very, they're made of something very special. So that's kind of a joke because obviously my numbers will be a wee bit more precise than a trillion. So let me frame it. The big picture, and I believe probably everybody kind of knows this, but just so we're talking about the same thing. This is from a piece I wrote for the Dispatch, and so just wanted to give credit there to the Dispatch for supporting that kind of stuff. Congressional Budget Office estimated about 1.6 trillion in federal student debt, around 37,000 per borrower. There are private loans, of course. There are state student loans too, not too many. There are, and so that brings it up to 1.78 trillion. And then it just mentions there the growth. Okay, so that's one thing I wanted to sort of just level set on. The other, on the right-hand side, something that I think is a common misconception. So the things that I've got on the right are, there's a lot of talk about, well, the government just sort of pours an infinite amount of money into the student, funding or the student loan, so students can go out and spend as much as they want on college, and so of course college is super expensive as a result. Um, there is a very general truth in that as long as you don't pay attention to any of the specifics. It has been the case for a long time that undergraduates are limited in how much they can borrow per year from the federal government themselves. And so the issue that parents will run into if they come running up against the kids 18 going to go off to college and they haven't really thought about it very much is, hey, we were figuring we'd borrow, it's going to cost 22,000 a year or whatever, which is a pretty common number. We figured we'd borrow that. And the answer is, sorry. Now the parents can, but the kid can't. The kid can borrow sort of like 6,500, 7,500 a year, generally speaking, and it's capped at around 30,000 per student for undergraduate for the student to borrow from the feds. And so unless the student's going to go to the private market or the parents are going to go into Parent Plus loans, which happens a lot, the students themselves can't go more than about 30,000 for undergrad. So that's something to keep in mind. And the other side of it, and another point that not everybody sees is that loan balances have been rising for a long time. So students are just making, what's been going on in the student loan system for many years now has been systematically Americans of all ages, because it's not just young people, but Americans have been making the minimum payment on their credit card, if you will, in the student loan space. And so balances have been rising because people haven't been, some of it's been on income-driven repayment plans. I'll mention those in a second. Some of it has just been the minimum available payment on kind of a regular plan. But the interest rates aren't necessarily that low on these things. And so loan balances have been going up. So one of the arguments that you'll get in favor of saying, like, we have to do something about this, and I mean, I would agree we have to do something about this, but is, look, the system is broken because the average loan is getting bigger, not smaller, which has been true for some years. Okay, so that's just some level setting. A couple other things that I will share. What are the most recent developments? Really the easiest thing to do is to just look at what are the most recent press releases, that have come out from the Department of Education. They are promoting what they're doing pretty actively. And so it's not really being concealed. It's just a little hard to kind of sum it all up. And so I will do that on the next slide. But the most recent announcements, actually, I should say, April 12th was a helpful one just because they're announcing 7.4 billion, an additional to another 277,000. But the subtitle there, Biden-Harris administration now approved 153 billion, for 4.3 million borrowers across the country. And the one on the little snippet on the top here relates to the main vessel, like the main program that this administration has really loaded their kind of hopes into in terms of this as a policy in a political matter. It's called the SAVE plan, SAVE plan. I think there's a decent chance that the SAVE plan will have, I actually think it will have more impact even than the final, like the current proposed rule that could become final. I could be wrong about that, but that's the way it seems to me. And then below that, this is the most recent press release. This is May 1st. And so this was, 317 borrowers who attended a specific set of proprietary schools where they've discharged all of their debt as a result of that. That's a pretty big category of debt discharges, like the administration going through and just systematically identifying people who attended, in all cases, proprietary or for-profit schools that the administration, that one way or the other have closed, but usually under regulatory scrutiny. And so then they turn around and they say you don't owe that money anymore. So a bit of a scorecard, and this is not comprehensive. I don't think a comprehensive one would quite be possible outside of the agency. But so what are we talking about here? So I said that I think the SAVE program, this is the name that they've given to their main sort of repayment program. So they want, and they've just been like beating the drum really hard to get every federal student loan borrower to sign up for the SAVE repayment program, which basically kind of brings into one place all of the most attractive, from the borrower's perspective, terms, conditions, features of like what do you have to pay back, and so it's based on your income, and there's very favorable kind of conditions under which you don't have to make payments at all, and there's et cetera. The math of it, just sort of, as the administration is very kind of out front with this, the math of it is that there's a good chance you won't have to pay very much at all for your loans. Like, that's kind of what it comes down to. So that's so far, so I've listed here what's the program, that's down the left hand side, how many borrowers, like, to date, this is just as of now, how many borrowers have been impacted positively from their perspective. What amount is the administration saying that they've forgiven, right? Because we start with 1.6 trillion. You say, well, I don't know, how much does it come down? So here's a little bit of an idea. And then potential impact, I only filled in one, but the thing with the SAVE program that I just wanted to note is that some groups that have studied it have estimated that the SAVE program could wipe out as much as $500 billion in debt of that 1.6 trillion. But then, public, just running down real quick, public service loan forgiveness, that's been big, because like the SAVE program, that second line there, public service loan forgiveness, that very much relates to people with graduate debt. And that's where the big numbers come in, is if you have debt from a graduate degree. And so public service loan forgiveness and SAVE both sort of impact people that have graduate debt. Income-driven repayment, this gets a little bit, there's a little double counting here, not in the math of it, but just like a little bit of overlap. But what is the case is that historically you have these different payment programs, and people were signed up for different things at different times. And there are people who, are in their 50s, 60s, even 70s sometimes, who are still making student loan payments. And so the full system would not fit on this slide if you start looking at everything that's going on. But as far as the big rocks, the big chunks, I tried to put them here. There's closed school, as I mentioned this, I just called it that, but different secretary actions to say, hey, your school closed, or you were defrauded by your school, or you have another basis to say that, the school was bad. And so the Democratic administrations have always been very eager to do that. And it only relates to proprietary institutions. And so if your nonprofit school closes, that doesn't count. Okay, so lots of borrowers affected there, 28.29 billion. Total and permanent disability. This is where people are just judged to have a total and permanent disability. I got, they say, 548,000 people who fit that description, and relieved 14.1 billion on that basis. And then the last one, the new proposed rule, it's where we stand now with the new thing. And then I've got one more slide to give you a bit of a sense of the shape of that. There is a proposed rule. It was brought out for a 30-day comment period, not 60, 30 days. And so that goes for another few days here, and then that comment period will close. So last I checked, it was 28,000 comments last night. So a bunch of comments. And I mean, a lot of them are, well, all the ones I found were identical, but maybe they count as different comments. Anyway, the new proposed rule is expected, or said by the administration, it'll affect 30 million borrowers. That must be all of them, right? I don't know. So what is the new thing? So this is my last slide, and then I'll take the slides away, and we can stop with the PowerPoint. I thought this was the easiest. As you can see, I kind of snipped it from the official NPRM, the proposed rule. This is maybe the simplest way to say what is the new thing. The new thing has, and I'll just go by kind of the numbers here, the following different elements. So 30.81 and 0.82 are kind of the same. One is a waiver of the current balance when it exceeds the balance when you started repayment. If you were on an IDR plan, that's the first one. And it's kind of the same thing for the second one if you weren't on an IDR plan. Waiver based on time since the loan first entered repayment. So again, another similar thing. It's basically what the administration is proposing to a great extent is, if the loan balance has grown, if it's bigger, that just goes away, right? Then 84, waiver when a loan is eligible for forgiveness based on a repayment plan. So you have had all of these repayment plans in the past where you needed to do certain things to qualify. And the administration is saying, well, if you didn't quite, or didn't maybe at all qualify, but you seemed like you were generally in the space, then the secretary will use the waiver power to be able to waive. 85 is similar when a loan's eligible for a targeted forgiveness opportunity. It's a different flavor of, hey, we kind of had the authority, we didn't do before, you probably didn't quite qualify, but we'll just say that you qualify. Point 86, waiver based on secretarial actions. That is awfully vague, but what it means is the secretary, and almost invariably with respect to proprietary or for-profit schools, says, you school have been bad in some way. We're going to say that the borrowers don't owe the money, right? Now, interestingly, of course, it's the taxpayer that doesn't get the money back. It's not the school that's, I mean, theoretically, the school would be affected in the long, long run, but in practice, that never happens. And then, 87, waiver following a closure prior to secretarial actions, same thing, right? So the school closes. Waiver for closed gainful employment programs, that's very similar. So the school is still open, but the administration's taken action against a proprietary school because of the gainful employment rule, which has to do with, are the graduates earning enough money? And so that's what the new thing is. The new thing, unless something changes between the proposed and final rule, really relates to undergraduate borrowing. So it's not that there aren't large amounts of money, in play, but as I said before, like the really big individual balances are, again, almost by definition, are graduate, kind of graduate loans. So, so I will did I just succeed in stopping sharing? Is that right?
Yes.
I did. Okay, good. Couldn't tell. Press the button. I'm going to say a couple last things that are more, and I'm happy to, just kind of we'll answer questions and have the whole discussion. But a couple of things I would say. There's a thing called negotiated regulation. That's the whole long process at the Department of Ed. I skipped over that in terms of how rules are developed under the Higher Ed Act. It is the case of what you do is you bring together what they call negotiators who represent different kind of constituencies, and those constituencies, they sort of all get together and they go through a set process, for figuring out what the composition of a rule will be. And what that does is it sets the terms for what the department will release as a proposed rule. Now, at that point, it just looks like any other proposed rule, and it gets commented on by the public, and then you kind of move forward from there. So in a sense, you could say it doesn't matter that much that you do negotiated rulemaking. In practice, it's sort of, you've brought a lot of people into the room to crowdsource the contents of a rule, which is what's happened. And so it has a little bit more behind it. So that's one thing. So something to say that relates to kind of rule of law type issues. What was the group that was brought together to do the negotiated rulemaking? Actually, you know what? I will go ahead and can't resist to show you this. So here's the group that was brought together for the we call it NEGREG, the negotiated rulemaking. And these are people that are meant to be sort of contesting different sides of an issue, right? So you have civil rights organizations, legal assistance organizations that represent students or borrowers, state officials, where we had Oregon. So the first person listed as the primary, and they really are the only person. And then there's an alternate, right? So then you have state officials, so that's Oregon. You have state attorneys general, that's Massachusetts. I highlighted Josh Devine. God bless him, hung in there from Missouri for like several rounds of this. And then finally, it looked like in the final round said, look, I don't think I'm being productive here, because he was an alternate and was literally the only voice in here that was saying anything remotely like, should we consider taxpayer issues? Public institutions of higher education, private nonprofit institutions of higher education. It's hard to imagine any of these groups being opposed to just, right, giving it away. Proprietary institutions, historically Black colleges and universities, federal family education loan lenders, services and guarantee agencies. Maybe it'd be interesting to see what they had to say about these things. Student loan borrowers who attended programs of 2 years or less. Student loan borrowers who attended 4-year programs. Student loan borrowers who attended graduate programs. I mean, right. So they're assembling basically every different flavor of people who would be very much in favor of not having to pay their loans. So that was the composition of that. The other thing that I'll say that I think is maybe systematically important over in the future, if you read the new rule and think about what system it creates, the new rule is enabling the secretary to, on a discretionary basis, waive the obligation of repayment for different categories of borrowers going forward, right? So that, in the regulatory impact assessment, I've never seen, and this is super nerdy for people that are into this, but I've never really bothered to much read a regulatory impact assessment. It's a required element of every proposed rule. If you read it, it's quite interesting because they're estimating not just the backward looking, how much are we going to forgive, but also like on a forward looking basis, right? Because the people who take out loans this fall and next fall and next fall and next fall will become eligible for these waivers. And so what the system sort of contemplates, or what it would become if this becomes a final rule, is a system where, in practice, depending on who happens to be the Secretary of Education, which might, depend on elections and stuff, you might have to pay or not. But there's an evergreen pile of borrowers. I think they have to keep doing the edit there at Ed to scratch out voters and right back in borrowers. There's an evergreen pile of borrowers that you can either forgive or not, depending, right? Depending. It's discretionary. So that's an interesting thing. People have had the criticism, including myself, of like, hey, nobody seems to be talking about what this thing looks like going forward. I mean, we're talking about like doing relief in hindsight, but what's the plan going forward? To me, actually, if you look at what's there and you think about it, you go, well, this is kind of a long-term plan, right? Everybody keeps borrowing. We preserve the discretion to forgive significant chunks to significant groups. And that just creates a ton of value, right, for folks who are maybe going to have an election. So I will stop with my comments right there and would love to hear from, I'm very interested to hear what the others have to say.
Thanks, Dan. Sheng?
Hi, thanks for all that, Dan. With that in mind, I think I would like to kind of run through some of these programs and discuss, in particular, the legal aspect of them, and specifically whether or not these forgiveness programs, how they fit into the congressional authorization. I come from a world where agencies cannot do whatever they want. There's a difference between an agency rule and a statute that's passed by Congress. And to preserve the separation of powers that's set forth in our Constitution, we have to limit all agency rules, no matter how good you might think they are, within the statutory authorization that Congress granted the agency. So I'm sort of agnostic here as to what is a good student loan policy versus what's a bad student loan policy. And what's more important is the student loan policy authorized by what our lawmakers said the department can do. And while this program is framed as the Biden administration's student loan forgiveness programs, I think to start, we really actually have to look at what happened during the Trump administration, where we were actually all in the government. And there, in the height of the pandemic, if I can take you back there, Congress actually passed a law that paused student loan repayments for everybody because we were in a pandemic, and it was very difficult economically for some people. And what happened was they enacted the CARES Act, which said all student loan borrowers did not have to repay their loans, and interest did not accrue on those loans. And that was to last 6 months. And this was actually pretty expensive. Just the non-accrual of interest was costing the Treasury about $5 billion a month. And that was fine. My organization, we're about the separation of powers. We take agnostic view on the wisdom of that policy, but it was legally enacted. And when that policy ended, 6 months, so it was March to September, and in August 2020, the Trump administration decided to unilaterally, through the executive action, extend it. And they didn't actually come up with a very good statutory justification for it. But they said, we want to give Congress, and Congress is still debating what happens next. The pandemic is very dangerous. We're just going to extend it unilaterally without going to Congress. And nobody really, complained, because again, we all had other better things to do. So they extended for some time, came to December, they extended again, and the justification was always, we're giving Congress more time to decide what to do with student loans. And each month, $5 billion of interest gets forgiven. In comes the Biden administration, and they keep on doing the same thing. And it wasn't until, I think it was, correct me if I'm wrong, but I think it was the end of the Trump administration where the Secretary DeVos issued a notice that actually finally, for the first time, invoked a statutory authorization for this. And the statute they decided to invoke was this 2003 statute for service members called the HEROES Act. I'm sure the reason you might have heard about this in the context of the other Biden administration cancellation, but it actually started back in the Trump administration, the use of the HEROES Act. And that statute says the secretary may waive or modify any statutory or regulatory provision applicable to student financial assistance programs when it's connected to a national emergency. And so the thing that they were waiving and modifying, it's the expiration date of the original CARES Act, right? It was supposed to be 6 months. We're modifying 6 to mean 12 months. Then we're modifying 12 to mean 18 months, et cetera, et cetera. And then the Biden administration came in and did this over and over again. It stopped being we're giving Congress time to enact something because it became quite apparent Congress wasn't going to do anything about this. And so the Biden administration kept on I think it was like 3 or 4 months at a time, but it was 7 or 8 extensions, again, at the cost of $5 billion per month. So it was hundreds of billions of dollars by the end of this, multiple years. And it was quite regressive. I mean, this is sort of a policy point, but because the reason is the folks who benefited the most from not having to pay interest and not having to make repayments are people with large amounts of student loans. They tended to be doctors and lawyers who took out large loans and now earn large salaries. And they benefited most from this, whereas folks who took out some loans from community college or some college, they weren't getting much because their payments are relatively low. But this went on until summer of 2022, when the Biden administration decided, well, we've been doing all of this under the waiver or modify power of the HEROES Act. What if we do more? And that's when the $400 or $500 billion mass cancellation program was born. They said, well, we're still in a pandemic, and the statute says may waive or modify anything. So we're going to waive and modify a bunch of loans. And it was, $10,000 for most borrowers, $20,000 for some Pell Grant recipients. And then this was the August 22 program. And that's the one that a bunch of people sued, including my organization. But the one that got to the Supreme Court was the one filed by the state of Missouri, where I think this was before Josh Devine was there, but it was his predecessor. And they were the ones that got to the Supreme Court. And all these suits, the key issue that on which these suits hinge was on standing. Who has standing to bring these suits? And Missouri was able to get standing because they had a state agency that was actually a loan service provider. So if you forgive a bunch of people's loans, Missouri will lose revenue from the loss of loans. Supreme Court said that was good enough, and then analyzed the merits of the Biden's mass student loan cancellation. And there, the court looked at, looking at the decision. Well, how far does waive or modify get you? And remember, it says you have to waive or modify a statutory provision. And the Department of Education for that mass loan cancellation said they were waiving or modifying these various provisions like disability, right? They were extending the scope of forgiveness for like the disability provision, or the scope of forgiveness for the bankruptcy provision. So they weren't waiving the loan itself; they were waiving a provision. The waiver power didn't really apply because they weren't waiving a statutory provision. They were trying to modify a statutory provision to be more expansive. The Supreme Court said that's not good enough because the word modify means to change modestly. You can't change a statutory provision that really extends to a few 100,000 people and say it extends to tens of millions of people. So the court could have ended it there and said the HEROES Act waiver modify power doesn't let you do this, but it went a little further than that and said something that I think applies to all major student loan cancellation programs. And that is extending what's called the major questions doctrine to the concept of mass student loan forgiveness. The idea is a massive government program, such as billions of dollars of student loans being forgiven, must be justified by explicit statutory authorization. A vague provision saying waive or modify, whatever that means, just doesn't cut it. And there's, there's debate about where the major question doctrine comes from, whether it's a good idea or not. But the core is the Supreme Court said this doctrine applies to mass student loans. So now, but that wasn't the end of the issue, as we know, because before the ink was dry on the Biden v. Nebraska decision, that afternoon, the president came out on the White House lawn and gave a speech about new student loan new student loan programs, and so one of which, so I'll just go through them quite quickly. So one of them is actually the after effect of the pause, because if under the Biden v. Nebraska decision, if the waiver modified doesn't let the president just forgive hundreds of billions of dollars that way, then the same rationale kills the pause. There was no court decision about it, but Justice Kagan's dissent even recognized under the same rationale, you can't, modifying 6 months to mean 12 months to mean 18 months. That's not a modest change. That's a transformative change that goes beyond what the word modify means. And so Biden v. Nebraska really meant the pause had to end, and it did end shortly thereafter through legislation. But so the pause still has some after effects, and the after effects are actually quite significant. Daniel was pointing to all these press releases of the president pointing to public service loan forgiveness, X billion here, Y billion under this plan, Z billion under that plan, and all those plans require something to require borrowers to make what's called a qualified monthly payment for a number of years. Sometimes it's 10, sometimes it's 20, but they actually have to make qualified monthly payments. Now, during the pause, nobody was making qualified monthly payments because they didn't need to. What the department did was they said, all those years, 3 years of people not making qualified monthly payments, they now count as qualified monthly payments. Non-payments count as payments now. And you can use those to accelerate your pause. So if someone was on a 20-year forgiveness plan before and they made 18 years of payments, you add 3 because they weren't making they're now past the threshold of 20 and they get their full forgiveness. If they were on a 10-year forgiveness plan, you add 3. They were at 7, you add 3, they now get their forgiveness. So all those, boasts from the White House, 6 billion here, 7 billion there, not all of it, but a significant portion of those are resulting from the after effect of the 3-year pause that is accelerating terms of forgiveness. And when you accelerate forgiveness, you don't just make it faster, you actually get more forgiveness, because the deal was I was supposed to make 10 years of payments before you forgive all my loans. But if I only made 7 years worth of payments, you're forgiving 3 extra years of loans to me. And there's, I think that cost it's hard to calculate, but it's still probably in the billions or even tens of billions over time. And my organization, the New Civil Liberties Alliance, is challenging that aspect of the on behalf of the Cato Institute and the Mackinac Center, the free market think tanks. We're challenging that aspect of forgiveness. And that litigation is actually before the Sixth Circuit right now. So marching down, Dan also mentioned the SAVE plan. And the core aspect of the SAVE plan, it does a lot of things, but the core aspect of the SAVE plan is it makes monthly payments very low, and then it forgives everything after 20 years. And the way this works, it actually goes beyond what, if you look at what Congress authorized, it goes far beyond that, because in 2010, Congress authorized actually a program that lets you make low monthly payments with forgiveness after 20, sometimes 25 years. And the one here, I just got to look at my notes, because the one that Congress authorized in 2010, or actually made a previous plan more generous, is that your monthly payment is capped at 10% of income excess of 150% of the poverty line, right? So what the SAVE plan does is it lowers that cap, and it says it's actually only 5% of income in excess of 225% of the poverty line. And as a result, many people are making 0. And if this gets you to 0. If you make less than 225% of the federal poverty line, which is about $40,000, $50,000, depending on your family structure, you make 0 monthly payments. And then after a number of years, 20 years generally, everything is forgiven. So this is a huge amount of excess forgiveness, and essentially converts a lot of loans into grants. And the statutory authorization that the White House used for this was not that 2010 statute. They couldn't do that because that 2010 statute sets out very explicit thresholds. Instead, they reached further back into a 1993 statute. And all the 1993 statute is that the department shall have authority to establish what's called an income contingent repayments plan that shall be based on the borrower's adjusted gross income and is not to exceed 25 years. There was no provision for forgiveness of any debt after that 25-year period. But there was an understanding at the time that some of this debt, like any debt, anybody in the business of making loans, some of this debt will just be written off. Some number of banks, obviously, if you mortgages, car loans, et cetera, you just won't be able to collect against some people. But the expectation is you have to set a program where a payment plan where the income contingent repayment plan ultimately has to be a repayment plan, not a kind of forgiveness cancellation plan. And you can see this because the plan doesn't actually have any limits. Under that language, you could have a plan. The White House didn't, but nothing would stop them if they were right. And that all the statute says is it shall be based on your adjusted gross income and repayment shall not exceed 25 years. You could have a program that says your repayment is 1% of your income above $1 million a year is your maximum payment, and everything is, has to, and everything is forgiven after 1 year, right? Under their logic, that can be done. And it just seems very improbable. That's what Congress meant in 1993. And under the Supreme Court's Nebraska decision, with the major question doctrine, the need for explicit, clear statement, I don't see how that authorization is going to pass muster. This is a huge program. As Dan mentioned, it was $475 billion, I think was on your slide. Right now, there are 2 lawsuits in the very early stages challenging this program. One is filed by Kansas and a group of states. The second is filed by Missouri and a group of states. And of course, Missouri had standing based on the Nebraska decision, so could very easily have standing based on this MOHELA organization. In this case, these cases are in very early stages, so it's kind of too early to say or too early to tell. They've been filed, just a few weeks ago, but that's kind of where they are now, and we'll watch to see where they go. And finally, we have the new rulemaking, and Dan gave a very good overview of what it does. I think there's actually one thing that they haven't actually put in the NPRM, but they said they will, and that is some kind of extra forgiveness for people under economic hardship. They haven't defined what economic hardship is, but it'll be something, and we'll probably see it in the summer. But for this new rulemaking, I just want to talk about the, it's quite a lot of money. There's a lot of components to it, but ultimately that they're hanging it on a statutory authority called Section 432A of the Higher Education Act, which dates all the way back to 1965, and they look at the statute that says that the part that says the secretary may compromise, waive, or release any right, title, demand, et cetera, et cetera. And then they say, oh, may waive. That means we can just waive whatever we want, doesn't it? Since 1965? It's kind of strange that since 1965, the secretary has had this authority and yet never exercised it. Instead, the president has gone back to Congress over and over again asking for, authority just to forgive student loans, and sometimes Congress gives them and sometimes it doesn't. But if this president always had this waiver authority, why would anyone even bother making new student loan forgiveness laws? And of course, that's not what the statute says in total, because if you actually look at the whole thing, it says in the performance of and with respect to the functions, powers, and duties vested in him by the Higher Education Act, the secretary may compromise, waive, et cetera, et cetera. So what you really have to do is look at the functions, powers, and duties vested in him by the Higher Education Act. And there are functions vested in him that allow him to forgive loans, like the student, the public service loan forgiveness plan, the income-based repayment plan that Congress authorized in 2010. Those are duties vested in the secretary. He has power to waive loans in pursuant to those duties. But he has to essentially 432 allows the secretary to, you need another hook, basically. 432 allows you to waive, but the secretary still needs to find another statutory hook and to actually exercise that waiver power. And the White House's, the Department of Education's notice of proposed rulemaking didn't identify any statutory hooks that gives them that forgiveness power other than 432. And with that, so I suspect there will be, when this thing gets finalized, in probably much like how they propose, there will be a slew of lawsuits. And again, based on the Biden v. Nebraska decision and the need for a clear statement under the major question doctrine, that will likely get knocked down as well.
Thank you, Sheng. Stuart, what do you make of all this?
Well, I don't know if I have a whole lot to add, given that very fulsome explanation of the pros and cons that Sheng just went through. But let me start in a macro sense and first suggest how I became interested in this issue. Along with Professor Larry Tribe, a liberal, I'm a conservative. We represented El Paso, Texas, in the border wall litigation, criticizing the Trump administration, in essence, from exercising legislative powers under the guise of a national emergency. President Biden's initial activity under the HEROES Act resembled that to a significant degree and was validly criticized, in my view, for that reason. A cynic, and maybe some people who are not so cynical. I mean, I've been a supporter of the Biden administration in many regards, and an opponent of Donald Trump in almost every regard. As I say, a cynic might suggest that irrespective of the rule of law, what the current administration is attempting to do is buy favor with a segment of the American society most likely to keep it in office. And when you look at that, I think you can see that a very valid argument can be made that the cost of loan forgiveness is going to be much higher than the benefit to the economy, that it disproportionately benefits higher income Americans. And as I think is implied by what Sheng was just describing, is only going to offer a temporary reprieve before total outstanding student loan rises again. Student loan cancellation provides little economic boost relative to its projected cost when doing nothing to identify drivers of growth in student debt, namely soaring tuition costs that have outpaced the growth of median wages. And in part, at least there's a strong correlation, and I suggest a result of the fact of loan guarantees. It's analogous to what we saw in the late 90s with regard to the S&L guarantees, that this sort of governmental intervention in the economy only encourages colleges and universities to raise tuition. And I think it's a fair statement to see that was done. Now, that's a political background, and let me put a couple of dollar signs on it to add to the ones that Sheng was talking about to demonstrate why the fundamental requirement for the major questions doctrine to be applied still exists and will be confronted in these newer lawsuits under the SAVE program, the HEROES Act now having been cast aside. About half of all outstanding student loan debt is held by individuals in the top 2 income quintiles. Those individuals are much less likely to have trouble paying back their loans. What's more, that families under the Biden approach, and this is still the case, it's a little less true because of some of the targeting under the newer program, but it's still true that those families in the top 2 income quintiles will receive more than half of the benefits associated with student debt relief. So it's fair to say that canceling student debt would alleviate financial burdens facing many millions of Americans, but it's going to cost the government a lot of money, and it's going to benefit people who don't need it relative to others who do. Forgiving $10,000 in student debt per borrower over the total economy of outstanding student debt would cost roughly $245 billion, while forgiving $50,000 per borrower would cost $950 billion. Now, that's a lesser number under the recent program, but it demonstrates that there is this effect. And the major questions doctrine is not really elucidated tremendously well in Biden against Nebraska, but it is in West Virginia against EPA, which is the major questions case that the Supreme Court decided now 2 terms ago. This is something that has a major effect on the economy. These are significant dollars. I mean, one might argue, indeed, I have argued, that too many people are arguing that whatever ox they have that's gored qualifies as a beneficiary of major questions analysis. I don't think most of these things do, but I think this one does. It affects a broad amount of people, and it rewards some unnecessarily, perhaps unfairly, and I'm being asked to pay for it. So are all of you. So are all of the listeners to this. So it's something where I think that the Supreme Court will decide in the first instance in these more targeted suits. Recognize that the current lawsuits are not complaining about everything. The Biden administration recently has forgiven some loans that were the apparent product of fraud on the part of non-educational institutions, if you will, the Trump University type of argument. That's obviously something that is sui generis. It's not within this totality argument that I'm making. But under as Sheng said, and I'll just reiterate in closing, that the many states under the leadership of Kansas, Alabama, Alaska, Idaho, Iowa, Louisiana, Montana, Nebraska, South Carolina, Texas, Utah, Missouri. It's a long list of states that are hoping to benefit from Missouri's recognition of standing in Biden against Nebraska. They are arguing in essence, as Sheng has outlined. I don't need to repeat that in detail, but what's going on? I mean, the one thing to note, the HEROES Act analysis was a complete legislative grab. It was legislation by executive fiat. The current situation is being governed by the Administrative Procedure Act. There's an actual rulemaking. And there's notice and comment. A lot of the trappings of a valid rule are taking place. So the question ultimately that the Supreme Court will have to answer is this stuff arbitrary and capricious or otherwise not in accordance with law, and that will go back to what Congress intended, which is hard to fathom in cases like this where you're looking at multiple pieces. But Sheng's 1993 focus, I think, is a pretty valid place to look and see that Congress really never intended, especially the feature of SAVE that allows borrowers who took out relatively small loan amounts to qualify for loan forgiveness in as little as 10 years, especially when most of them, a majority of them, are in categories that render them relatively affluent. So I think we're going to see that sort of challenge. I think it was the Chief Justice who really put his finger on the problem in the decision of Biden against Nebraska in applying the major question doctrine. I think that the idea of it, that as the Chief Justice pointed out in that case, it's difficult to see that Congress somehow authorized a program that allows mass debt cancellation under the guise of other forgiveness, especially with regard to this fictitious idea of non-payments being counted as payments. I'll rest and now await the questions and thank everybody for their contribution to what is an interesting issue, probably aggravated in light of some of the current conduct that we're seeing on some college campuses.
You know, I don't know that this is legally significant to the analysis, but you know, it's interesting and maybe significant to our kind of political culture that this. You know, I think it was Speaker Pelosi who had said multiple times that this student loan forgiveness can't just be done by an act of the president. We need legislation in Obama immigration amnesty or legalization of folks illegally present. You know, he had said multiple times to supporters, this is not a thing I can just do. We need legislation to do it. Trump asked for money for the border wall, didn't get it. So, you know, you have multiple instances of high-profile executive action falling the explicit inability to get it done legislatively. And you know, kind of what is that? I don't know if that matters to a case other than setting context, but it does seem to matter to the civic. It does seem to matter to the broader civic culture that when presidents cannot get their program through Congress, they increasingly seem to feel free to find other ways around it. I know, Sheng, and you focus on these kinds of issues. Do you have any kind of thoughts on how that either figures in the litigation or on kind of the broader American understanding of how our system works?
Yeah, I mean, the New Civil Liberties Alliance where I work, we focus on a lot of separation of powers questions. And one of them is to cabin the executive departments in the executive department's lane. And we see this all the time where members of Congress or members of one party will try to pass some kind of legislation. And maybe sometimes they get pretty close to it. And then the executive branch comes in and says, you don't need to pass legislation because, legislation requires compromise. It requires give and take. And there's a cost to it because if you don't give what your constituents want, maybe you'll get primaried. Both sides. If you give too little, if you compromise with the side, you might get primaried. If you don't give everything that your side wants, you might get primaried. So the better way to do it, well, the more politically expedient way to do it is to ask your friends in the executive branch to do it for you through executive fiat. But we know, the Constitution doesn't allow that. And here in this particular case, I think, I'm not against student loan cancellation per se. I think you can do it in a way that focuses towards people in real need, lower income folks who've been defrauded. You can do it in a way that that gets concessions from universities who are responsible for sending people out in the world unable to earn a living and enough to pay off their debts. You can do these things, but that requires legislation. But you never get there if everyone in Congress can just call up their friend in the executive branch and say, do me a solid and do my job for me.
I would just add to that. I mean, this is in my experience, this goes back to the 1940s, and in my actual experience, to the late 1950s. It's not something new, and there are ancillary problems associated with it, like leaving vagaries in legislation that does pass and kicking interpretation to the courts where it doesn't belong, encouraging judicial legislation. As I often say when I speak publicly on this issue, you may quote the framers in claiming that they intended there to be energy in the executive, but they didn't intend to have torpor in the legislature. Their focus, there's a reason why Article 1 is Article 1. The framers intended the legislature to be the voice of the people and the predominant political branch, subject to checks by the other branch. Our current Congress is not something you'd put in charge of a 3-car funeral. They're incapable of acting in many regards that are imperative to the national interest. As Sheng points out, and I as an actual conservative, somebody who really believes in limited government and fiscal responsibility, you can target loan forgiveness and other kinds of relief to people like those who were defrauded, like people who give countervailing consideration to the government by doing public service, or in essence establishing a new contract where there is a public benefit over and above the original loan contract. But this is a situation where there is enough that can be described as executive legislation that I think it is not improbable that the Supreme Court, even with regard to the difference between the HEROES Act rationale and the SAVE Act rationale and the intervening rulemaking, where the Supreme Court still can apply that major question doctrine. And I note that one can say that against the tableau of the court also revisiting Chevron deference, as it did our deference several terms ago. Where there is less deference being given to the executive branch, and the court telling the Congress, look, you can justify these policies. And the Supreme Court said so in West Virginia against EPA. But if you do, you better state it clearly so that we know about it. And I think that is something that could continue to apply with regard to student loans. Take this out of, if you really want to do something, take it out of the environment where you might get this cynical response that the Biden administration is looking disproportionately to benefit the well-off, people who might vote for them, college-educated women, for example, and put it into where both public equity can be considered and the overall national interest can be considered. As I say, we're being asked to pay for this stuff, and the cost of it is not insignificant, and it is arguably isn't necessary. So there are targeted and better ways to do this. In terms of the rule of law, there certainly are better ways to do this.
Dan, we haven't spoken to you for a while.
Yeah, I mean, a few kind of thoughts. One is this is actually an area, and echoing off of Sheng's comment about not necessarily being opposed to loan forgiveness in some cases. The thing about student loans is that you cannot overstate how unyielding the system has historically been, because it is uniquely, well, I'm not a bankruptcy expert. I think it's uniquely an area of debt that can't be discharged in bankruptcy. And the stories of people whose lives have been like permanently put in like on hold, essentially, because they've gone through bankruptcy, but they've discharged everything other than the biggest thing that they have. I mean, it's terrible. And so, I think I would favor a system that, as long as the other characteristics were also using the price mechanism and free markets and all this kind of stuff to function, would include, as everything else does, recourse to the bankruptcy courts. And so there's that, and so the thing is that what the administration is trying to do goes way beyond who would be eligible for treatment in bankruptcy. But the stories that they're able to collect, I mean, there's an infinite number, effectively, of highly sympathetic stories that they can go out and find, because the system has been so rigid on the one hand, right? And so that's kind of part of at least the talking points on the thing. And there are a lot. I mean, I got no problem with certain relief. It should have come through bankruptcy. At this point, it's accumulated to the point where it's not going to happen right now. And so, but it's a tiny fraction of the total. I worry about the way that we've eroded kind of the culture. At the end of the day, right, everything is about culture, and it's, do you have a culture and expectation of repayment? People, take out loans or not based on their kind of beliefs about the world, right, to a certain extent, and then they repay in certain ways, and just it really is about that. There's a thing that we haven't talked about that I'm not sure was, I think it's quite unnoticed, actually, because it has always been a little vague what the department's actually doing, which is that they have this thing called their on-ramp period. So what they said, and I haven't been able to figure out what's really going on under the hood, but what they said was, well, for the year after we start repayment, we are not going to report to the credit bureaus if you don't pay. Now, they weren't saying that you didn't have to pay. They weren't saying what would happen if you didn't pay, but they were saying that you could just not pay for up to a year, and that, not only would they sort of back off from the credit, they wouldn't report to the credit bureaus, but there was some of their language about, like, sort of essentially they wouldn't come down on you the way that they normally would. So what is interesting too is that this culture, right? So back to my original point, you have students who took their first loans out in the fall of 2016. They go to 4 years of college. Let's suspend disbelief and say they graduated in 4 years square. Some people still do. They come out, therefore, in the spring of 2020. So from 2016 to 2020, they probably haven't been making payments. And then in 2020, so you've got folks who didn't pay from 2016 until payments restarted at the end of the pandemic, and at this point may not have started again. I mean, there's reason to believe many of them haven't, but it's just that we have no way of knowing. The system, right, has no way of knowing. And I think the culture of, this is a debt that I need to pay, I mean, we'll see, right, how much people feel like, hey, I have to pay these things.
I think we are coming up against the hour, but the broader cultural questions are, I think, a great place to end the body of our discussion, because though we are the Society for the Rule of Law, law is just sort of a tentpole of the culture, and there's so many consequences and broader considerations that we ought to be discussing. So thank you all. If you want to quickly have a final thought, comment, or plug you'd like to share before I wrap things up, I welcome you to.
I will just say to anybody listening, I'm going to send my slides to Gregg, and Gregg will personally handle every request or any information at all that you need. I'll send the slides to Gregg, and they've got some more information than what I shared if anybody's interested. There you go.
Thank you. And do read Dan's New York Times opinion piece, which is in the chat, Sheng. Do you have
Yeah, I
anything?
just want to go back to this point where I think if you actually care about the student loan borrowers, I think you would want this to be a congressional fix, because that's a long-term lasting solution. You don't want a situation where you're seesawing between administrations where you get low payments during a Democratic administration, then the rule gets canceled and everyone's payments balloon in a Republican administration, and no one can be able to plan fiscally for the future that way. So even if you do want this, there's a way to do it, and that is through Congress.
Thank you. And Sheng, I think if people want to learn more about your organization, it is the New Civil Liberties Alliance. And is that ncla.org?
That's right, and I have to put in the plug that the Chevron decision being we discussed here is one of our cases this year. So we're hopeful for depends on what you mean, but we hope we win that one.
Well, that's for another seminar. But the Loper case is certainly something that people ought to be watching. In terms of litigation, it is probably the most significant case that the court is going to decide this term, except for Trump versus United States. But I'd also note that in subscribing to the view that Congress ought to be doing its job, note that we're debating a program here that, for well or ill, only postpones a problem. That student loans will continue to increase. That total portfolio will continue to increase, and to the extent that there are people who are overburdened and are facing horrific situations, that will be magnified in the future. This is a problem that ought to be solved the right way, consistent with the rule of law. Is one optimistic about that? Well, there's little reason to be optimistic about that, but hope never dies.
Well, thank you all for a really rich conversation. I very much appreciate it. Again, to our audience, those who are watching live or who will follow this up on YouTube, there'll be a recording where you can watch this and share it with folks in the future. Remember, again, we are a membership organization. I really invite you to consider joining our society at our website and joining us for our next event, which is in 2 weeks on the presidential pardon power. We have a lot more interesting programming in development, so please check back on our website, follow us on social media. We have a YouTube channel, Twitter, and we're on LinkedIn as well. So thank you all very much. I appreciate it, and we will see you in a couple of weeks.
Thank you.
Thanks.